Once I'm done with this, I'll go get that stuff from Mr. Ardmore.
All right, good. We call 25 CR 263, the state of Texas.
Before this case even officially gets called, pause for a second, because what you're about to see is one of the most confusing, high-risk decisions a defendant can make in a courtroom. This isn't a minor charge. This is burglary of a habitation, a felony in Texas that carries up to 20 years in prison. And yet, right from the start, there's tension in the air. We've got a defendant who doesn't speak English fluently, an interpreter sworn in on the record, and a judge who's already leaning forward, trying to understand one simple question. Why would anyone turn down a deal this good? Deferred adjudication probation is not something courts hand out easily. It's often a second chance, sometimes the last clean exit a defendant will ever get. And in just a few moments, you'll hear Judge Stevens explain exactly what's on the table and what's about to disappear forever. So pay close attention here, because this case turns not on evidence, not on witnesses, but on a single decision that could change this man's life for decades. Would you gamble with 20 years on the line?
Oh, go ahead.
Judge, we previously had this case set for trial.
Yeah, why did we take it all?
I asked for it to be set today so that I could speak with him
Okay.
in an effort to figure out where he's at on the case and whether or not there was any conviction possible.
Okay. He's charged with burglary of a habitation, which carries with it up to 20 years in prison if convicted. And where are we on the attempts to resolve it without a trial?
Mr. Hammond's made an offer of a deferred adjudication probation.
And he's not accepting that.
Correct, Judge.
Okay,
And
that is odd. The court will.
This is the moment where courtroom veterans instantly raise an eyebrow. The judge flat out says it. Turning down deferred adjudication is rare. And he's not exaggerating. Legally speaking, deferred adjudication means no conviction on your record if you follow probation rules. Rules most people already live by every day. Don't commit new crimes, stay sober, handle your responsibilities. That's it. And here's the kicker the judge lays out clearly. On deferred probation, a defendant can often be released in 1/3 of the time. 10 years probation could realistically mean freedom in just over 3 years. So when the defendant still says no, the tension spikes. Is this confidence? Bad advice? Or a misunderstanding amplified by language barriers? The judge makes sure, repeatedly, that the defendant understands the stakes. No deferred probation after trial, no jury option for it, and a conviction that almost never gets erased. So ask yourself honestly, is this bravery or a catastrophic miscalculation?
Trial, that's what the Constitution stands for. But deferred or unadjudicated probation also allows a defendant to be released in 1/3 of the time of probation if the defendant does well, and that's what the court does regularly. And I don't know if he knows that or not, because if it was 10 years probation, he could be released in 3 1/3 years and move on with his life if he did well.
So we were able to talk about all that today, Judge. And I can say that we have thoroughly considered it. In this case, I do believe that there are issues suggesting factual innocence.
Okay. Well, if he goes to trial, he doesn't get deferred or unadjudicated probation by a jury. That's not allowed.
He understands that.
And they would either acquit him or convict him. And if he's convicted, he could go to prison for up to 20 years. If they grant probation, it's a conviction. And it is seldom erased.
Yes, sir.
When you were finally convicted. He understands all of that.
Yes, sir.
You understand all of that.
See.
Okay, then this As long as he intelligently and voluntarily weighs the issues, it's his life. He can make the decision he wants, and we will set this.
And just like that, the door quietly closes. The judge makes it crystal clear. Once this offer is rejected today, it's gone forever. No deferred adjudicación later. No second chance after trial. From here on out, it's all or nothing. Acquittal or a conviction that could carry a sentence of up to 20 years in prison. What makes this case so powerful isn't shouting or chaos. It's the calm, methodical way the judge ensures the defendant fully understands the consequences before honoring his choice. This is the justice system at its most unforgiving and most fair at the same time. Now I want to hear from you. Did the defendant make the right call, or did he just gamble away his best chance at freedom? If you found this case as intense and shocking as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns you won't see anywhere else.